You know, the worst part is that when you make a good first impression, but somebody steals the record and then they give it to somebody else. And then they tell you to do it again, and you have to deal with the disappointment that came, that knowing that on the spot, extemporaneously, you were authentic and you did a very good job. But, well, they don't want to acknowledge you did the job. So let's see, first of all, what was it that I was considering on this time frame? What does this say? I was able to keep this record. What does it say?
The basic purpose of obligations in a capitalist society is determined by the fact that they are a legal means of realizing the surplus value produced by workers and appropriated by capitalists, as well as a legal mode for extracting elements from circulation which are necessary for the repetition of production cycles, each of which serves as a source of new profits. The bourgeois law of obligations is subordinated to the purposes of capitalist exploitation to the same extent as the law of ownership and as all institutes and branches of bourgeois legislation in general. Therefore, bourgeois jurisprudence always aspires in its theoretical constructions to present the obligations of capitalist society in an impersonal class form, as though this did not contravene reality. At various stages in the development of capitalism, the said aspirations are manifested in various forms. ... In the system of norms of modern bourgeois legislation, the norms of the law of obligations are one of the strongest means for consolidating the positions of capitalist monopolies. Even as some official politicians of capitalist countries recognize the basic purpose of contract in bourgeois society is to serve as a means of subordinating the market, seizing spheres of influence, and displacing competitive producers. The very structure of contractual ties applied in capitalist countries is used for this purpose. These and other analogous phenomena oblige modern bourgeois civilistics to reject the treatment of the contract as a freely individual act based on the autonomy of parties. Some say that the individualist understanding of a contract harmonious with the economic conditions of the early 19th century is contrary to the new organization of society, and this, in their view, constitutes one aspect of the socialization of the civil law. Others, without excluding the use within certain limits of the ordinary type of contracts, note that now, when the high level of production attained cannot be satisfied by the activity of individual persons, but requires the efforts of many people and even of all of society, state contracts are beginning to occupy the key positions. Others either reject completely the volitional nature of contract or restrict it within such limits that there is essentially no place left for free will. It is evident, however, that neither the frank acknowledgments to which bourgeois civilists sometimes resort, nor their aspiration to misconstrue the essence of capitalist obligations in any way changes the class orientation of the norms of the bourgeois law of obligations, which are in the service of monopoly capital and used for the purpose of securing and protecting their predatory interest. Well, this is not from the English common law or from the constitutional system. It came from the traditions associated with those engaged with English common law. It's from 1975. But inherent within it is a very, very compelling critique that finds a nice reference point in evaluating matters just discussed concerning not only the appropriate wage rates for people identified as employed in connection with contracts or subcontracts with the city of Chicago, relative to the propensity to award and allow for the proliferation of contracts with the Department of Defense that may be involved in constitutional violations, including those regarding impairment of contracts or impairment of meeting obligations on contracts or other constitutional amendments, which then calls into question consideration of the Constitution itself as a contract with the people, insofar as the Constitution is a contract with the people. Then what are the terms, and how and in what manner does one determine the obligations?
Well, that wasn't what I was expecting. The question it posed was, is the DoD contract scheme unconstitutional? Question mark. So this was from February 25th of 2021. The reading was from a book. I have the book here. But I wondered if that had anything to do with what I did the next night. See, the first effort was taken from me. It's over 15 minutes, almost 16 minutes, but all I have is silence. Somebody else has the first effort. I only have the second effort, which is almost what? Oh no, the second effort. Let's see what happened.
Well, it's obvious that unlike the other times, I have to redo this voice file because whoever you tried to take my identity and give it to is unqualified to actually follow through and be put on the record as having actually done what the research was just done in connection with this case. General Dynamics Corp versus United States. It discusses this concept of superior knowledge in regards to government participation in awards of government contracts. Not only that, it discusses matters relating to a state secret privilege, preventing adjudicating petitioners' superior knowledge defense, and discusses how held when to protect state secrets. I'm not going to quote it in that manner. In an effort to protect state secrets, it can be determined that the entities involved in the suit would be left as they were on the day of the contract, which does not also involve specifics regarding losses, but in terms of determining the status of the entities on the day of the contract. What I've just identified is, I believe, that this case is specifically set up to reveal what I believe happened with the TX Trainer contract bidding here in Texas specifically, if not in concert with others. There's a citation in the case by the opinion by Justice Scalia. I just saw it at the beginning. It discusses McDonnell Douglas Corp versus United States from 2009, and then McDonnell Douglas Corp versus United States from 1999. That's a 10-year difference between those two cases. And in this case, which has to do with General Dynamics, and references Boeing, but doesn't put Boeing in as an actual named litigant, is 2 years later. I.e., is it a form of what was identified as smoothing? And not only that, if there is, there's also a time frame between these, the first McDonnell Douglas case in 1999, which is identified as being filed on July 1st of 1999. Right now, there's no information on the congressional record about July 1st, 1999, and one manner in looking it up through the congressional record, but I'm sorry, July 1st of 2001. There's no information from the first week of July of the year 2000, the year 2001, which is what I was just looking up. And the reason this was for consideration is because of the concerns regarding the report that Ambassador Bremer provided before the Senate before the Congress in July 12th of 2000, which is what I've been inquiring about. In the reports twice, he discusses how changes to the Clinton-era policy around recruitment of intelligence assets were questionable, and that there were people within the Department of State and within the intelligence community that had serious problems such that they had determined they needed a closed-door session to discuss them. The concern then becomes, is there a correlation, especially in connection with the understanding that what this does is potentially provide an argument of discussing how individuals were subjected to forced cybernetic enhancements and or bioengineering, and that what was happening is that there would be a term or a time frame during which the contracting, under the authority of the government, the contracting would be made available for certain individuals, certain kinds of human capital to be made available for use by these companies that contracted with the government in the development of some sort of product. And then they would reverse engineer it as if to tear it down so that then it could be awarded as a contract to somebody else to either reconstruct or to create into some other kind of product. And that's the concern here, is that it demonstrates a possibility for those timelines. And if in fact what they're discussing in terms of this concept of superior knowledge being precluded because of a state secret, well, is the state secret connected to identification of people who were identified as assets that were then allowed to be used in processes of human test subject development for products that were awarded through military contracts? And so if this is the situation, then the question becomes one of a concern around swapping the actual human assets. And that part of what they're talking about here is the consideration of, you have assets that have been used by or in connection with some other manner of being, and then you have a time frame where you get to reverse engineer that product and then create your own. But if there is something about that process that doesn't deliver for you and your company the results you were desiring, including potentially taking a product that had been made for one market, including a foreign market, reverse engineering and then trying to recreate it as a new product for another market, and then it doesn't meet your expectations, then what are the considerations of the claim involved? And so what this would say is that if that was the argument, or if that was inherent in the argument, well, this concept of leave the entities as they were on the day of the contract. Well, the contracted company and the government entity with whom it is contracting does not say anything about all of the human capital that may be a part of whatever was the determination around the success of meeting those contract obligations. The people were potentially involved in lieu of involved without their informed consent in these processes, which is why what I'm seeing right now, the congressional record dated for July 1st, 1999, becomes even more concerning. The first thing I found was at the front here, but I went to something that had appeared, which is Open Market Reorganization for the Betterment of International Telecommunications Act. Senate passed so this is dated for July 1st of 1999, and it's talking about how the Senate passed it. So the question becomes, how long had it been before its passage that it had been proposed? Was it pending at the time that there were announcements that the Clinton administration had agreed to military satellite technology sharing with China? And so when this got passed, would this have been included? Then the question becomes one of the consideration of the use of the term betterment. And betterment is a specific financial accounting term that prior to the 1980s had not been used by any other industry except the railroad industry. But if we're talking, for instance, about the possibility of using a betterment as a sort of financial tool or as a sort of accounting paradigm, including potentially an accounting paradigm that would have to take into a consideration concepts of investment versus concepts of other matters that would be identified regarding the taxation, then does this leave open the possibility of a consideration of using the international telecommunications system in a process that would allow for the execution of what I've called terminating hedges. And so when the communication system is being applied, and when these that certain places have been specifically risk leveraged to bear a disproportionate share of calls for the delivery of terminating hedges to result in some form of liquidation, that then is allowed to be identified as or accounted for some kind of a betterment or something comparable to a betterment at that time frame. And so if you do that, and then you don't have an appropriate calibration, and you don't allow for the accounting to be done sufficiently, it also leaves open a possibility connected with the first thing I saw, which is on this record. It discusses S335 to amend Chapter 30 of Title 39 to provide for the non-mailability of certain deceptive matter relating to games of chance, administrative procedures, orders, and civil penalties in the nature of civil penalties relating to such matter, and for other purposes with an amendment in the nature of a substitute. And I've already discussed concerns regarding this concept of in the nature of a substitute and what it allows for in terms of options regarding processes and timelines that are part of the federal budgeting process when it comes to the benchmarking that would otherwise in good faith be used or be useful in a concept of an appropriate accounting for the federal budget and how that could be addressed in terms of providing for what the government needs to do. But if you don't do that, and if you, for instance, allow for some form of gamesmanship, comparable to what I understand happens with military fiscal law, and then you catch the government, or you catch somebody in the government being irresponsible or being derelict in their duty, then that accrues. So how long can you keep an individual under contract to be used as R&D by a contractor that is not that actual individual themselves? And to what aim and in what manner are they allowed to try to justify it? This also brings into consideration, as I was saying, these timelines, that if there is, as I am intuiting, and also I believe because it fits the situation of the consideration here, the 10-year period between the first case and the second case, and then the 2-year period before the case that is referenced here, as if they have a 10-year period to reverse engineer, create their own product line, and then they swap out the assets or whatever the base is for consideration to a new contract. So there's a new product line that's going to be developed. And then in the course of that, well, what happens if that new contractor is not pleased with what happened when it stripped it down and reverse engineered it? And so then it would be determined to, well, you leave on the same way you were the day you came in. Well, what does that mean? Do they get to swap out other assets from the public to replace or to offset whatever ended up happening? How do you determine what happened on the day you entered the contract? Especially if you've been put through that process more than one time. And then that brings up consideration of, well, was this connected to an understanding, a premeditated understanding that the Supreme Court of the United States had about what the Affordable Care Act was actually doing? The Affordable Care Act was passed in a specific time frame itself, right before what would have been 10 years from September 11th. But in the course of that, it laid in motion. If you look at the billing records, Billings did not actually start getting paid for the Affordable Care Act implementation until 2011. And so in that meantime, if you understand, as I have alleged, that the Affordable Care Act is a contract to commit to a criminal conspiracy, specifically a criminal drug conspiracy, well, the criminal drug conspiracy is a particular element in terms of the functionalization or the functionality of what the intention is. But what is the buy-in, and how is it that it is being able to be operationalized and literally put together, which brings up this concern regarding games of chance, non-mailability of certain deceptive matter relating to games of chance. So the concern regarding the naming of post offices, that in the last 2 years, since at least the end of the summer of 2019, many bills have been proposed for the renaming of post offices. And as I was saying, at the last 2 months of Trump's term, the last 2 to 3 months of Trump's term, a majority of the pieces of legislation he was signing were ones concerning the renaming of post offices, as if he was trumping the post office, or the renaming on the post office, or potentially trumping the sponsor of the bill. Because my concern was that what was happening is individual Congress people were proposing name changes for post offices in their district as if they were going to have their own specific kind of relay center, having something to do with the mail system specifically. But it also provides a particular kind of insurance possible in consideration of allegations of mail fraud. And for instance, using the substitute of a mailing that would otherwise qualify as an act of mail fraud, but then could be used as a derivative for some other kind of option or hedge, where the risk associated with it can also be addressed within a context of understanding that not addressing it and prosecuting it as mail fraud then allows for the accrual of a certain kind of liability that can be leveraged for what? And see, these are all the kind of things that they're giving out contracts for, isn't it? And not only that, they expect people who are deconstructing it to, or trying to investigate it as crime, which is what it is, to then cede to accepting that they are a patented product, and so they get exclusive access. And they get to take and deny us due process, which is inherent in this decision, this opinion that says, well, it's a state secret, so it can't be adjudicated. No, that's not appropriate at all, because what that does is it says that the Supreme Court is allowing for the abuse of the bench in order to provide cover for grievous constitutional violations, including systemically unconstitutional actions in violation of the rights of the people, and to what end? Especially if it can be proven that what's happening is they are bioengineering their own population under false pretenses and in violation of the Constitution to create products that are sold to those identified as enemies of the state, and then, after they do that, reverse engineering them to create new products that they sell to another group of people identified as enemies of the United States, after there was a process of intentionally sabotaging relationships with those countries based upon what they were doing with their own people.
Now we've got a consideration here. When I first came to Texas, it wasn't a law, but it is now. You are entitled to open carry a sword or a blade that is 10 inches long or less. The question is, where does the measurement begin? Is it the entirety of the metal past the handle, or is it only the sharpened edge that counts? Can you carry metal longer than 10 inches that has less than 10 inches of sharpened blade? Now that's a Texas law. But I believe an argument can be made regarding other arguments that have already been made concerning the Second Amendment and changes to the Texas Constitution.